now go to agenda item number 18, which is former agenda item number 1.
Report of the full council, item number 18, Council Bill 116268, relating to the premises use and occupancy agreement between the City of Seattle and the Professional Basketball Club, LLC, approving termination of the agreement in accordance with the Professional Basketball Club, LLC, and City of Seattle Settlement Agreement Memorandum of Understanding, and repealing ordinance number 122492.
Are there any comments on the ordinance that would provide for this termination?
It would be nice to have it in time to read it.
Well, it is what we were given essentially a week ago, and so I really appreciate Councilmember Drago pointing out that this had not been attached to the ordinance, which does seem like it was kind of an irregular thing to do. So we now have this attachment here, and it's now attached to the ordinance. Councilmember Harrell.
Are we discussing the substance of the ordinance now?
We are now, yes.
I guess I have more a question or concern, I suppose, that is, as I understand it, I guess the question I had earlier was, because there's still some uncertainty about the settlement, there's still some conditions that have to be negotiated, there's some language, as I understand it, in the settlement that talks about, you know, the lease can be reinstated. I guess the question earlier I had was, should we terminate the lease prior to all of those specifics being worked out? Were we doing it prematurely? And having researched this in the last hour or so, as I understand it, we really don't have much of a choice, because if you go to the settlement agreement, if the City Council did not terminate the lease, we basically forfeit the $45 million, as I understand it in Section 5. So I want to make sure that I'm proceeding with a correct understanding. The other issue that had sort of come up was, as I was better understanding the Seattle Sonic history section 6 of the settlement agreement, you know, we were looking at some stats that are now being, you know, tossed around like on ESPN's websites, and you'll notice all that stuff has shifted to Oklahoma now. So like you look at the 95-96 season where, you know, we were Western Conference champs, all that Seattle's deleted from it now, and it says Oklahoma, which is sort of apparently, unfortunately, where we're heading. So again, I want to make sure I'm reading the stuff correctly, because it was my understanding that a lot of the history, the memorabilia piece, all that was still sort of being negotiated. But if I'm understanding correctly, if we don't approve this, if we don't terminate the lease, we basically walk away from $45 million. So I'd just like someone to respond to that.
Well, I can respond to you and say that that is my understanding of the settlement agreement. And I think that for the public, I'd like to maybe take a couple minutes just to explain the history of this and how we got to where we are. And I'm not going to go into the whole history, because that would take a long time. But just in terms of this settlement agreement, the city essentially entered into a lawsuit as a result of concerns that the Sonics were about to terminate their lease or break their lease, which would be a violation of the terms of the agreement. And the lawsuit was essentially an attempt to get them to live up to the terms of their lease. The only thing that the city had the authority to do, we had no authority to compel them to remain after 2010, but the lease did provide that they had to remain in Key Arena for 2 years. So the city going into this lawsuit essentially was attempting to make sure that we did not wind up holding the bag if they broke the terms of their lease without providing compensation to the city, and in the hope that somehow there might be something else that would emerge that might wind up leaving a team here for a longer period of time. As time went on, it became clear that that was not going to be something that was likely to happen, and it seemed very dubious that that would be the kind of relief that would ultimately be granted, since there was nothing in the lease agreement that it would require any team to stay here after 2010. So as a result of that, the city attorney did enter into negotiations to attempt to come to a settlement of this agreement. And it's very important to note that that is a city attorney responsibility. The attorney acts with the guidance and assistance of the council and mayor, but the city attorney is the one who essentially has the authority to make a decision on whether to settle or to pursue a lawsuit based on his best judgment, again, with the advice of the clients, the council and mayor, as to what is likely to happen in terms of the city. So that is essentially the pattern that has brought us to this point, and we, none of us like this particular settlement. We don't think it's, at least I guess I should speak for myself, but I'd say for myself, this is not in any way the optimum solution that anybody was hoping for, in my understanding. The optimum solution that everybody was hoping for would be that the team would have found a way to remain here, and we would have been able to find a way in which to continue things. But that did not seem to be an option. And so the result of that was that we wound up with a situation where we had a negotiated agreement that we believe treats the city as best we possibly can in terms of our financial outcomes that might happen, and does give us the hope and the promise that at least there would be some consideration of a team in the future. I, again, want to say what I had to say at the news conference, which is that we should not have too many illusions about that. This is a hope and a promise. It is by no means a guarantee. And whether we can actually realize that is going to depend on a lot of very hard work over the next several years. So from my perspective, the real background to this and the real issue is that the NBA, the sports magnates, the people who own these teams, essentially are treating the fans as something that's fungible, that can be simply thrown away and replaced with some new fans when they feel like doing something like this and moving to another city, and they have made that decision. And the city of Seattle has done its best to try and figure out a way in which to mitigate or prevent that outcome. But we do not ultimately have the authority or control over that outcome. It is a private business, and a private business that makes decisions based on their own business considerations. So the fans are the people who are being tossed about and who are being essentially left in the lurch by the NBA and the companies associated with them. And we are fortunate that we've finally found a way in which we can at least get that relationship a little bit better so that we have the prospect of possibly doing something in the future. But we should be really clear that this is not an outcome, at least from my perspective, that we would have wished for. Councilmember Harrell. Okay.
Thank you for that. And again, what I'm trying to do is zero on what we're trying to do today, and I just want to make sure I have a correct understanding of what's occurring. As I understand it, if the Schultz litigation is successful and the team somehow is required legally to come back, then the lease will be reinstated according to the settlement agreement.
That is correct, yes.
If for whatever reason today we did not approve the termination of the lease, then we would in essence walk away from the $45 million, and the city would proceed in litigation only on the specific performance claim, not on the money claim, not on the damage claim. So we can proceed with litigation, but only on the issue of specific performance. And I guess, well, I'll stop there, and I think that's what we're doing today, as I understand it, because again, I was trying to get up to speed on this fairly quickly.
Yes, that is correct. And if the city won its lawsuit, essentially the court would then return and say, well, you either have to stay for 2 years, or you have to find some way in which to buy your way out of that 2 years, but could make no guarantee about what would happen 2 years from now. Are there any other comments?
Yes.
Councilmember Burgess.
Well, I want to take this opportunity to slightly change the subject. 6 months ago, we sat here and passed a resolution asking the mayor and the director of Seattle Center to negotiate a lease for Key Arena with the Seattle Storm. We voted unanimously in favor of that resolution. The mayor concurred with us. And when it became clear that the Sonic Storm organization was going to leave Seattle, 4 local women stepped forward and negotiated the purchase of that team, and that team is playing at Key Arena and playing quite well, I would mention. And now it's time for our city government to step forward and make sure that we successfully bring a conclusion to those negotiations for the Storm to continue to play at Key Arena, and so that Seattle take the steps necessary to make sure that the Storm remains economically strong and viable in our city. And I think it's important for the mayor and the Seattle Center director to know that the council is unified in our desire to see that a collaborative process brings that lease negotiation to an early conclusion.
Thank you. And Councilmember Drago.
Well, to quote Council President Conlon, it is a sad day to lose the Sonics. But on the flip side, we did help save the storm. And this council was very instrumental in helping to save the storm, and with the strong support of the mayor. With the severance of this lease, it has significant impacts on the storm organization, because the storm and the Sonics have, from the beginning, been sharing practice space, equipment, administrative costs, and personnel. And now that means added costs for the storm. The storm play a minimum of 16 games here during the season, and more if they make the playoffs, which they did once. That was pretty glorious. So 16 games is significant. It's probably the largest user of Key Arena. So we need to do what we can to support the storm, keep them vital, and keep them in Seattle.
Thank you. Any other comments? Councilmember Harrell.
Looking at today's legislation, I see we're repealing, of course, Ordinance 122492. In that ordinance, there is significant language devoted to the storm, but we're terminating the lease with the Sonics, but in that same lease, we're not terminating or modifying the lease with the storm, correct? None of this affects that.
It's a separate
That's correct.
It's a separate lease, okay, so.
But weren't they owned by the same organization? So terminating the lease with them, would that have any effect on the storm?
Well, what I know is that the storm does have a separate lease, which they are negotiating now, and that needs to be completed by September. So it is it's a separate lease for Key Arena.
There is no lease in place for the storm now. If this is separate.
No, there is a lease in place for the storm, but it's not part of this lease.
We have a signed lease.
I believe so, because they are negotiating, they're in the process of negotiating a lease.
Okay, are there any other comments?
No. Again, I'm not going to be, I'd look back, I've been trying, there's not a copy of the lease anywhere around, so I went back and looked at the ordinance, the original ordinance, which apparently, and that was the 122492, that we're repealing. In that ordinance, there's considerable language devoted to the storm, so I have to assume that this lease that we're terminating, no one has a copy of that in front of them, apparently. So what I'm hearing then is that lease specifically applies to the Sonics. That's a separate lease, and we're repealing the ordinance that does contain storm language in there, but this isn't a problem, what I'm hearing.
It's my understanding that the original lease was only with the Sonics, that the storm were added later to that lease when the storm were created, and that what we're repealing is the agreement with the football club that actually at one time owned both of those, but we have a separate lease now with the storm because it is under different ownership.
Under that section 6, about halfway down.
Settlement agreement?
Yeah, on the settlement agreement. In reference to the question that you had before, it is a little odd, but it does say that the PBC further agrees that if an expansion team is approved by the NBA within the next 5 years to play in renovated Key Arena, then the owner of each team and the PBC are free to use and refer to the Sonics history, statistics, player histories, and records during the NBA seasons prior to the date of this MOU that the Sonics played in Seattle. PBC further agrees to the extent requested by a new team owner it will transfer at no cost the team's banners, trophies, retired jerseys to such owner, providing that such owner acknowledges the memorabilia as shared history. So I guess I read that they get to use the statistics now until there's another team.
I read that differently.
Did you?
In fact,
well, you're the lawyer, so.
No, the language you read I had underlined here because, and I was a little shocked and disappointed that I'm looking back at the old stats, and where Seattle once was, it's plastered with Oklahoma. And I was reading that as to say that, you know, within 5 years, if we don't get a team, then they can start using it sort of interchangeably. It's sort of quite frankly, it's a little ambiguously worded, and so so I went back to Section 5 to see, quite frankly, whether we had any ability not to terminate the lease, to keep the lease in place until we make sure the settlement agreement is a good, solid agreement, because if you look at Section 1 and Section 2, it's very clear that another settlement agreement is forthcoming in August 1st. And so in a perfect world, then we would not have terminated our lease until the August 1st agreement is executed. We're not doing that here because what's going to sort of carry the day is Section 5, which lists today, July 14th, as the drop dead date that we have to do that. So I'm going to support the termination because the way this is structured, we really don't have a choice. Otherwise, we're walking away from $45 million that I don't think anyone would want to do. But it seems, again, to me that we would have structured this a little differently. We would have waited until all of this stuff is clear, till the final agreement was put in place on August 1st, 2008, and then we would have terminated the lease. But again, the way this is drafted to me, I think our hands are a little tied.
Okay, let me ask another question.
Sure.
Okay, we are giving you, as president of the city council, the authority to execute this settlement agreement memorandum of understanding dated July 2nd. What about the one that's forthcoming on August 1st? That's not referenced in here.
You know, you're right. That is not referenced in here. And the one that is on August 1st is intended to be substantially in accord, as I recollect the wording is. Parties agree to complete the settlement agreement no later than August 1st. Yeah. So essentially, you're right. It looks like that is not something that the council would be asked to approve,
Yeah.
or that I would be signing.
And Councilman Drago, to your earlier point, I think it's clear at this point that they are not, PBC was not to use the statistics unless we are not granted a team within 5 years. I'm reading this. PBC further agrees that if an expansion team is approved by the NBA within the next 5 years to play in a renovated Key Arena, then the owner of such team and the PBC are free to use and refer to the Sonics history.
Okay.
So, but again, ESPN is a third party. We don't have control. They're not standing to any of these agreements, but they're proceeding with our history.
I guess my interpretation of the settlement agreement question is that the agreement is intended to be only working out the details. As it notes, it shall be in all respects consistent with the terms of the MOU. So I don't know that as how important that would be to have the council be a signatory on that settlement agreement, because the MOU really contains all of the key terms. But that's just my interpretation of it at this point. Councilmember Rasmussen.
What I was wondering, I'm so glad that Councilmember Harrell has reviewed this and has brought up some important points. For example, if an organization like ESPN incorrectly lists Oklahoma, who is it that brings that error to their attention? Is it the city that has to do that, or is it Oklahoma? It seems like if the burden is always on the city, we're going to be chasing this frequently, this error, and I think it would be better that it should be Oklahoma that ensures that these kinds of provisions are carried out. And so who is responsible for ensuring that when a third party makes a mistake like that, or either intentionally or does it unintentionally, that they correct that?
I believe the agreement is silent on that. So I can't answer that question. I do want to note that I guess some of the issues that have been brought up here, to me, really reflect the problems with devising a settlement agreement on the run. And that is that, yeah, I mean, the fact is the settlement agreement, because it is, you know, rather than really settling down and negotiating something out, the settlement agreement was essentially put together very fast over a very short period of time, immediately prior to the deadline set by the judge being prepared to issue a decision. So all of these kinds of questions are the sort of thing that, to me, in a methodical and deliberative way, should have been addressed in a more thorough process. And it's a great example of what happens when you actually wind up having to do something rapidly, and you do the best you can, but there are a lot of details that are left that perhaps should have been ironed out in a more careful and thorough manner. That's about all I can comment on it.
It clearly states the settlement agreement will supersede this MOU under number 1.
I'll be very blunt on the point. Maybe I've beat it around the bush a little bit, but the city council was pretty much put in a rock and a hard place on this. The fact of the matter is we were holding hard and fast on our litigation path. We were believing in our legal position, and then a settlement was brought about very quickly toward the end, and in that fine language that I think we were presented with literally hours before the judge was to rule, that language contained a clause in there, number 5, which suggests that if we don't terminate the lease by today, that we walk away from the $45 million. And, you know, we are put in a fairly precarious position when we settle litigation like that, and we are then requiring city council ratification of it sort of a short period of time.
Exactly. Yeah. Okay. Are there any other comments? As I said, not a cheerful day. I am going to have to say one more thing, and that is following up on some of the comments that have been made in regards to Key Arena and the Seattle Center. We have also heard that Seattle Center is going to have to, as we know, take account of the fact that they have a number of dates now that they no longer have a game that is scheduled, and that they're going to have to rework all of their concession agreements. They're going to have to rework a whole number of other things that in order to make the Key Arena function effectively, including signing contracts with people for some of those dates, figuring out how to manage the concessions, figuring out what happens with the naming rights. All of those things are going to be things that Seattle Center may have to act on fairly quickly. So I had originally asked that some consideration be given to including in this ordinance authorization for Seattle Center to actually move forward with some of those things. But because that would have been not necessarily in accord with the title of the ordinance, is my understanding that's why we did not get those provisions brought in here. But it is something that we're probably going to have to take action on in the near future in order to give the director of Seattle Center the authority he'll need in order to make those, enter into those leases and agreements over the next several months prior to coming up with a sort of final formal plan for how the Key Arena is actually going to operate. So that is something we're probably going to have to, I think it may need another ordinance on our part to allow that authorization. Councilmember McIver?
In which case, should the Seattle City Council retain an attorney to advise them on the actions that be proposed in those other ordinances?
Well, that's a very interesting question. And that is something that we should take under advisement. I agree. Okay. Are we ready to vote? Councilmember Rasmussen.
Well, when you talk about Seattle Center having to scramble to fill those dates, Seattle Center is people, and the employees are affected because they were planning on working those hours and those days, so there is harm there. And to say nothing about all the businesses in the community and around Seattle Center that were depending upon the patrons who would be attending those games. So there will be a lot of people scrambling to figure out what to do next as a result of this.
Definitely, and I guess the only optimistic thing I can say is I know the director of Seattle Center is fully aware of the fact that his job is to try and bring some more events in as quickly as possible and to do that as rapidly as possible to get more activities into the Key Arena. So that's a good thing, but it is definitely going to be a struggle. Okay, please call the roll on the passage of the bill.
Licata.
Aye.
McIver.
Aye.
Rasmussen.
Aye.
Burgess.
Aye.
Drago.
Aye.
Godden.
Aye.
Harrell.
I need a moment. Aye.
President Conlon.
Aye.
8 in favor, none opposed.
The bill passes and the chair will sign it.